Hello and welcome to the Mitchell Law Tea Break. I'm here with Catherine Mitchell and the title for today's tea break is Culture Clash. What we mean by that, what we're talking about, are cases which arise in the context of a conflict of views, particularly where those views are tied in with protected characteristics.
Yeah, I think the classic example here is where a conflict arises between the right to hold and express religious beliefs and those beliefs potentially clashing with another person's right not to be subjected to detriment or harassment on the grounds of their sexual orientation.
True, we could just shorten that down and say gay cake cases, couldn't we?
Gay cake cases, if you like. Although there are other examples, bed and breakfast cases, cases around membership of religious organisations.
Of course, none of those examples are employment law examples, are they?
No, it often arises in the context of goods and services cases. So if I'm a Christian in business and I'm asked in the context of that business to do something that goes against my religious beliefs, for example, bake a cake with a message supporting gay marriage, can I refuse to do that? And that's a goods and services case, but the principles that arise from those cases are read across when these issues crop up in an employment context as well.
That's right. Of course, there is some case law that comes directly from the employment law fields. We're going to talk about that for later, but just for now, let's come back to cakes, and in particular this cake that you're going to see on your screen now. That was the cake that gay activist Gareth Lee ordered in 2014 from Asher's Bakery in Belfast. Of course, where gay marriage was and still is unrecognised in the law. Now, the bakery refused to make it. I'm not sure if history records who eventually did make it. They clearly had better icing skills than I do. But backed by the Equality Commission in Northern Ireland, Lee sued Asher's over their refusal to make the cake.
That's right, and since 2014, the case and that simple question at the centre of it has been through every level of court up to the highest in the UK. And for the first time, the Supreme Court actually sat in Belfast at the start of May to hear the case.
Is it fair to say that we care less about the outcome of the case than we do about them not announcing a decision between us recording this conversation and putting it up online?
Well, almost. And I think the smart money is on Mr. Lee winning his case. He's won at the lower levels, and the nub of the answer given by the Northern Ireland Court of Appeal is that a service provider is entitled to refuse to provide a service at all, but it can't refuse to bake cakes with a particular message and only bake cakes with messages they agree with. I think there's a lot in that, and personally, I believe that it's in line with previous authority. Maybe we could do a follow-up where I eat a hat-shaped cake if the Supreme Court goes with the bakers.
Maybe. Before we leave cakes, and I think it's getting to the point where that might be a good idea, viewers might have heard that America has had its own gay cake case. Have you got anything to add about that?
Well, it was a case about a Colorado baker who refused to make a cake, again ordered by a gay couple to celebrate their marriage. And the US Supreme Court has very recently ruled that he was entitled to refuse.
Okay, so as things stand, we have a different law about gay cakes on two different sides of the Atlantic.
We do indeed, although in a way the Supreme Court has kept its decision very narrow, and it was at pains to emphasise that on slightly different facts there could have been a different result. It's worth remembering that the US Supreme Court is much more political than the UK Supreme Court, as well as the obvious point that they're applying different laws. So it would be a mistake to think that the US decision was any indicator of what might happen here.
Well, all the chat about cakes is indeed fascinating, and it's going to make me hungry. The last time I checked, I don't think we had any clients who are bakers. So let's talk about where this tends to come up in the employment context.
Okay. Well, firstly, where workplaces that are themselves religious in some capacity. So churches, church organisations, church schools, obviously the equivalent in other religions. And not all religions, for example, or all strands of Christianity take a view on homosexuality. So it will depend on the individual circumstance. And also because gay marriage is a relatively new and in some quarters at least controversial expression of gay relationships, anything wedding related might potentially give rise to one of these situations.
As an employer working in that sector, it may well be that the business is happy to treat a gay couple in the same way as any other couple, but you might have an individual employee who raises an objection because of their own religious beliefs, and and that then puts you in a sticky spot potentially.
Yeah, I yes and no, I think, is the answer there, because if your employee said they didn't want to be involved in serving customers of a particular race because they believed them to be inferior, I don't think you'd have any problems in not only refusing to entertain that, but also showing them the door, however genuinely they held that belief. And the belief that homosexual relations is morally wrong or offends against a religion is more widely held and recognised, but it's not a view sanctioned by the law, and therefore it's not surprising that your right to manifest that view and inflict it on others in the course of your employment is pretty closely curtailed.
Yeah, I think we can probably all understand that, and that there are two cases, the cases of Liddell and McFarlane, that are key here. Ms. Liddell was Registrar for Islington Council. She refused to carry out gay marriage ceremonies in her role as a registrar due to her own religious beliefs. Similarly, Mr. McFarlane was a counsellor with Relate, and he was not prepared to commit to offering the same sort of counselling to homosexual couples as he would offer to heterosexual couples. And both argued in practical terms that other employees could cover that work and they could effectively have an exemption. And it wasn't disputed by the employers that was right, but what the employers said was that wasn't enough.
Yeah, and I think, having a workaround is going to be problematic, and in each case the employers successfully argued that because the whole ethos of the organisation was committed to equality, it was incompatible and undermining to have employees who wouldn't commit to the whole of the role. And those cases went right up to the European Court of Human Rights. So it's high-level authority in these cases.
I do think it's really interesting to draw a comparison with the different demands that might arise from an employer's religion. So if Ms. Liddell or Mr. McFarlane had said, for example, they're not able to work Sundays, or if a Muslim employee had to interrupt their day for prayer commitments, it's fair to say that employers would be expected to accommodate that, provided of course that it was practical to do so. But of course the fact that I might want to pray at certain times, or I might have certain dietary restrictions, that's not undermining my employer's wider commitment to equality in other areas. So there is a difference there.
Yes, quite, and there's a different balance to be struck when you're weighing up competing rights as against the more basic exercise of weighing up the needs of the employee competing with the needs of the business.
Yeah. Before we wrap up, there is a 2014 case which I think is worth a mention. That's called Mabui, I think it's Mabui, and New Park Childcare. In that case, an evangelical Christian employee was dismissed following discussions in the workplace about homosexuality and religious belief. However, it was found in this instance that the woman had been questioned about her personal beliefs. She had answered those questions honestly and in good faith. And then when those discussions came to light, the employer had dismissed her in a knee-jerk response without stopping to consider whether she was actually seeking to manifest those particular beliefs in an inappropriate way in the workplace. So effectively in that case, a clash had been manufactured where none really existed. And I think there is a lesson to all employers there about not potentially overreacting to differences of belief that might exist within your workforce, where they're not being manifested in an inappropriate way. So it's always worth treading carefully, and of course we would say getting good quality advice if you find yourself in that situation.
I think so. And I think if you asked Asher's Bakery, they'd say that there was a clash manufactured when Mr. Lee chose an overtly Christian bakery to order his cake from. So we need to be alive to the fact that a degree of provocation isn't usually an answer to a claim. And although you're absolutely right, the employers need to be alive to the Mbaye trap as well.
Yeah, there can be several different ways of looking at these cases and several different layers. A bit like the cake, if it's a good one. It's interesting to discuss it on a moral level as well as on a legal one. I hope you've enjoyed our chat. If you would like advice or to discuss any of the issues that we've raised, then please do get in touch. Otherwise, we hope to see you again next time. Thank you.